Honorable Chief Justice and Justice of the Supreme Court of Michigan. All persons having business before this honorable court are admonished to draw an eye and give their attention. The court is now sitting. God save the United States, the state of Michigan, and this honorable court.
Good morning. This is the second case of our morning call of October 10th. Justice Wilder will not be participating in this case. There will be, as always, 30 minutes per side for argument, and in addition, there'll be a waivable 5-minute free-fire period should you wish to take advantage of that. Our first case will be Shelby Township versus Command Officers Association. Please proceed.
Thank you, Your Honor. Craig Lang appearing on behalf of the defendant, Shelby Township, in this matter. I will take responsibility for retaining 5 minutes for rebuttal. I've had the privilege of negotiating collective bargaining agreements and working in the public sector under the Public Employment Relations Act, or PERA, for over 40 years. I've negotiated hundreds of contracts and been involved in innumerable Act 312 proceedings. And I can represent to this court that prior to the passage of PA 152, the most contentious issue in collective bargaining was health care. The reason it was so contentious is simply because the costs were going up exponentially, and the world in which we lived in the public sector was that the public employer was responsible for paying for those costs as they rose. Attempts that we tried to engage in to reduce benefit levels, to reduce costs, and attempts to involve employee contributions to pay for health care plans were really very limited in terms of their success. PA 152 changed that. It removed the contentiousness that we've had in collective bargaining by making the public employees and the unions that represent them stakeholders in the cost of health care. It established a cap, either a Section 3 cap, which was a hard cap, or a Section 4 cap, which is depending upon a percentage. And the costs for health care above those caps are borne by employees. Since the statute is passed, negotiations have changed. I would suggest to you and submit to you that if the Michigan Employment Relations Commission decision in this case is permitted to stand, that we will return to that period of contentiousness, because employees will then be able to negotiate as a mandatory subject of bargaining their respective share of the total annual cost of the employer's health care plan. There are 3 issues before you this morning. 2 involve contract or statutory interpretation. The third involves a labor law issue. Based on my experience in labor law, I want to speak to you about the third issue first, as I think I can be most helpful to the court on that issue. The issue in this case deals with duty to bargain. And the duty to bargain in the public sector only arises when the union makes a demand to bargain. In this case, the Michigan Employment Relations Commission ruled factually that the duty to bargain was issued on January 6, 2012. That's important because 5 days earlier, on January 1st, the employer implemented employee premium sharing for this bargaining group, utilizing a bundled illustrative rate. At that time, there was no duty to bargain because the union had not requested to bargain. And 2 things I should note in the union's brief on page 3, they suggest that the demand to bargain was issued on November 22nd. That is not consistent with the finding of the Michigan Employment Relations Commission, nor is the decision of the Court of Appeals, which indicates that the union renewed its demand to bargain on or about December 6th. Merck's decision on this is clear. The demand for bargain was received on January 6, 2012. Now, the importance of that is this. Once that demand was received, the employer was restricted from making any change in a mandatory subject of bargaining during the pendency of negotiations. In fact, in the Merck decision on page 8, they reference this. They say specifically the allocation and calculation of the employee's premium share is a mandatory subject of bargaining which the employer cannot change unilaterally absent an impasse in bargaining. That is old law. That has been around in the Michigan Employment Relations Commission forever. Now, we're not conceding that this is a mandatory subject of bargaining except for purposes of this argument. But let me say this. Then an intervening event happened. The employer became aware of an unbundled illustrative rate. What Merck said subsequently is that the public employer, Shelby Township, had a unilateral obligation to change the illustrative rate, to use calculate a different illustrative rate at that time. Now, if in fact the calculation and allocation of the employee's rate is a mandatory subject of bargaining which we could not change unilaterally, the unfair labor practice finding in this case was that we didn't act unilaterally and change the rate. In short, it would have been an unfair labor practice for us to act unilaterally, but the Michigan Employment Relations Commission found that we violated the act by not acting unilaterally. It is a legal paradox that they created in this case that this court must resolve. You can't have it both ways. And when they engaged and made this decision, they offered no rationale for it. If you read the opinion, you'll see that it is done as a matter of fiat without any explanation whatsoever. Our position is simply that this court needs to clarify, reestablish the old law, not let Merck issue a decision based on fiat without any rationale, and overturn this decision based on labor law principles established, longstanding labor law principles established by the Michigan Employment Relations Commission. That is the third argument. That's the labor issue. But there are two other issues that deal with statutory interpretation, and I want to address those now. It is our position that PA 152 and the determination of the employee's share of total annual costs, the allocation and calculation, is not a mandatory subject of bargaining. And I will start that analysis by looking at the Michigan Employment Relations Commission's opinion in Decatur, which the Court of Appeals upheld. In that case, they determined that the decision of whether you're going to implement the Section 3 cap, which is the hard cap, or the percentage cap, Section 4, is not a mandatory subject of bargaining. Under the law as it existed prior to PA 152, it clearly would have been. But Merck made an analysis that looked like this. They said that when you're looking at the employer's permissible cost, the total cost, it requires the combination of the total of the medical benefit plan cost for all bargaining units together as a total group. And Merck then said that as such, it's a single group analysis. You cannot have some bargaining units that are under the hard cap and some bargaining units that are under the percentage cap. It just doesn't work. So Merck applied a single group, that's their words, not mine, analysis to this and said, under the circumstances, we do not believe that this is a mandatory subject of bargaining. The employer can choose Section 3 or 4 without bargaining. Now, what they were in effect doing is looking at this statute from how amenable it was to collective bargaining. Like this Court's decision in the Bay City Education Association versus Bay City Schools. In that case, the issue resolved around, was it a mandatory subject, was it amenable to collective bargaining? This Court said no. That's the same ultimate basis Merck used in determining that the Section 3 or Section 4 cap is not amenable to collective bargaining because of the single group analysis. The same thing holds true here. The same thing. Let me give you two simple examples, although more are in our briefs. If, in fact, I have collective bargaining agreements in place with all of my bargaining units, save this unit, and everyone is paying 20% across the board, thereby we're meeting our obligation, we're paying 80%, employees are paying 20%, And this group, if it's a mandatory subject, this is a public safety group, can take this issue to Act 312, binding arbitration, under Public Act 312 of 1969 as amended, and take to the arbitrator that they only want to pay 10% of the total cost, the total share. If the arbitrator goes along with them, I've got everybody else paying 20%, they're paying 10%, and I am immediately non-compliant with Public Act 152. In short, mandatory subjects of bargaining can go to Act 312. Permissive subjects of bargaining, which we allege in this case is what this is, cannot. So another example, even if I'm negotiating...
Why would it automatically be the case that they're not in compliance with the statute if one bargaining unit happens to negotiate a better rate for its members and the later bargaining units, maybe those with less political clout, for example, aren't able to get to the same rate, but overall the township arrives at the statutory limit?
In my example that I used, all other contracts were in place and in effect.
But that's the township's problem, right? Justice Viviano is asking why shouldn't we assume the legislature meant to give different bargaining units the ability to negotiate a better deal? Maybe the legislature wanted to give any bargaining unit who could get first to the table a 10% deal, and then why shouldn't we read this language to have allowed for that kind of different bargaining unit? I mean, different kind of result from the different bargaining units. I understand it seems like a big problem on the other end of the bargaining table.
Yes.
But we're just trying to figure out how to make sense of the language.
Yeah. In terms of Merck's single group analysis, that is our basis for saying that whenever there's all the other contracts are in place, I can't go back to them and say all of a sudden I had something I didn't expect. They're all at 20%. They have no duty to bargain with me at the time. I'm in non-compliance simply because they're last in time. They got 10%. Everybody else is at 20%. And I can't go back to the others and say, oh, by the way, I made a mistake. Their labor contracts are in place. And I can, Your Honor, if in fact there are other contracts open, I can go back and discuss that, but I'm going to pit one unit against another, of course. If they're paying 10%, all other things being equal, I got to go back to the UAW and say, well, you've got to pay 30% because they're only paying 10%, all other things being equal. From the single group analysis of Decatur, we believe that this is not amenable to collective bargaining, and as such, under your Bay City Education Association case, is not a mandatory subject of bargaining but permissive. That's the second reason, or that's the first reason why it's not a mandatory subject. But there's even a more fundamental one which you are aware of, and that is the language of the statute itself. It says the public employer may allocate total annual costs of the medical benefit plans among the employees of the public employer as it sees fit. Those words are unambiguous and clear, I believe. Now, to that...
But, Counsel, couldn't as it sees fit kind of be a term that describes as it sees fit in the process of negotiation?
No. I believe those words are as written, sir, that as it sees fit accords complete discretion. It provides, in the context of the law, looking at a case like Centerline, this accedes this responsibility as a management prerogative. It lies at the core of entrepreneurial control based upon the language used and put in this statute by the Michigan legislature. And under those circumstances, it is a permissive, not a mandatory subject of bargaining.
If we were to interpret that way...
I'm sorry?
No problem. First off, good morning and
good morning.
Welcome to the court, and you're doing a great job. But if we were to interpret that way, wouldn't that ultimately allow for kind of unfettered power on the part of your client in terms of its negotiations? It would almost mean that there wouldn't be a negotiation. And wouldn't that ultimately, would you actually think that the legislature would mean to kind of really undermine collective bargaining to such an extent?
Well, I suspect that the legislature meant what it wrote here. But in answer to your question, I have to say in this case, in the case that we're looking at today, that is not the facts at all. The public employer in this case ascribed and put in place a 20% allocation across the board for everyone. There was no inequity in terms of what any bargaining unit in this community paid. Everybody paid an equal amount. And I would also state that there is political accountability.
Well, you repeatedly seem to be casting some murkiness over this as it sees fit language. Not only is it your central argument, not only is it not your central argument, not only is it not your initial argument, but now you're kind of saying it's dependent, of course, upon some kind of equitable result. And I'm not quite sure what you're trying to introduce in language that, at least on the surface, seems to be fairly clear. It's not absolutely clear to what the as it sees fit language may apply, but once we determine to what it applies, it's pretty darn clear language, is it not? And it does accord what my colleague describes as unfettered discretion, but you seem to be wanting to limit that unfettered discretion in uncertain kinds of ways to me. What does
Your Honor, if I've left that impression, I'm sorry. I don't believe that at all. I believe that the language, it says what it means. As it sees fit is clear, and what that means is that the employer has unfettered discretion.
So
I don't want it to be
could they
unclear.
ascribe different percentages across the various bargaining units and maybe even to the non-represented employees?
Could it under this language? Could an employer? Yes, I believe that they could under this language.
So they don't have to do the 80-20 that Shelby Township has apparently chosen to do.
They chose to do the 80-20 and apply 20% across the board to all the unions.
This language, is this I've been struggling with it. Is it a term of art in the labor law arena, or is it a new
Not in the
expression?
labor law.
In other words, if the legislature wanted to make it clear that there was an exception to PIRA, they could have done that in starker terms than this, right?
We have cases where subjects have been made prohibited subjects of bargaining, Your Honor. But in this case, I believe this language is fundamentally clear that the public, this sentence is, I think, clear from the perspective of the legislature. The public employer may allocate as it sees fit. And under such clear language, let me just say this, that...
But to go back to my first question...
I'm sorry.
You're saying it's clear, but it's not language that's typically used in this setting to mean what you're urging us to...
This is not phraseology that I typically see in the labor realm. Certainly we cited innumerable cases which use this phrase, and the court has looked at such language to accord absolute discretion to whomever is given authority as it sees fit. That case law is set forth in both the amicus briefs and our briefs, and the language has always been found to be clear and unambiguous as to its import.
But counsel, doesn't that really run afoul of PARA to say that? Because if you were to say, you know, looking at this from kind of a realistic perspective, if I'm within a collective bargaining unit and then we reach an impasse, and the minute that one of us says, hey, we're at an impasse, then your client would have unfeathered power to do kind of as it pleases. So if you were to kind of take this in terms of contextually kind of how we're approaching collective bargaining, wouldn't your argument ultimately make it almost impossible to have collective bargaining? Because why would I have collective bargaining if the minute that there's an impasse that's reached, then you have the absolute and total power and control to kind of exert your will on the unit?
Well, it's an excellent question. In the public sector, even on mandatory subjects of bargaining, which we're saying this is not based upon the management prerogative accorded the employer. In other than a public safety unit, the employer's obligation is to bargain to impasse. That's like that language I read to you earlier from the Merck decision. Once we reach impasse on a mandatory subject of bargaining in a non-Act 312 setting, the public employer has the right to implement whatever it is that it was negotiating. I mean, if the parties are at impasse.
I guess my question is that if we're going to follow that logic, then why would you even bother to negotiate fairly? It's within your benefit to have an impasse. If you can have an impasse, then you get to win. So why would you even attempt to negotiate if I'm able to say, oh, we're at an impasse, and then at an impasse, I get to basically impose my will upon you and the members? I mean, it's within your, if you were to interpret this way, it's basically your strategy should be to reach an impasse.
Well, we have a duty to bargain in good faith.
But if you have a duty to bargain in good faith, the thing is, isn't that outweighed by the fact that, I just don't understand how you can have this idea that you have to bargain in good faith, but then if you reach an impasse, you get to do exactly what you want to do. So how do you bargain in good faith when ultimately, if by bargaining in good faith, you ultimately reach a situation where you won't get as good a deal? Your incentive, based on your argument, would be to not bargain in good faith, reach an impasse, and then impose your will.
Well, I can only speak from my experience. In 40 years of probably negotiating, 400-plus contracts, I've reached impasse maybe twice. And the reality of the situation is public sector unions have clout. And they're not afraid to wield it. When you've seen, picket signs up, I'm sure, in various school districts and public employers when things don't go right in negotiations. Public sector unions have clout.
And but is your argument that it's because they have clout that's going to affect the negotiation? I mean, what I'm trying to talk about is you have two elements of labor unions. You have people who do the negotiations, and you have the political component. But the people who are doing the labor negotiations are basically going to be in a position where ultimately, the minute there's an impasse, I'm trying to understand what their bargaining power is under your theory is the moment that an impasse is reached, you win. You can do whatever you want at that point.
Your Honor, this is not my theory.
I understand.
This is long-standing Public Employment Relation Association, Public Employment Relation Law. This is how it has been since 1965 when the statute was implemented. Now, what happened with public safety units such as this is when we get to the point of impasse, they have a right to petition for Act 312 on mandatory subjects of bargaining. But all other non-public safety groups, it's not my theory, it is what the law is in this public sector. Our position on this, to be clear, is that the language of this statute clearly leaves this to the discretion of the public employer.
I want to get back to the language. So Justice Viviano asked you if it was a term of art that's familiar in the labor law context. It sounds like not, as it sees fit. I want to get back to as it sees fit. And obviously it doesn't mean, I would assume you don't think as it sees fit means that your client could do 80-20 for white employees and 50-50 for black employees, right? It doesn't mean
that would be discriminatory, and that would be discriminatory in a violation of Title VII. That is a issue outside of that would be any discretion that a public employer has is subject to the law.
Okay, well,
subject to Title VII.
PARA is the law, so I'm just trying to understand why, as it sees fit, abrogates PARA but doesn't abrogate other laws.
From the context of PARA, 40 years ago in the Central Michigan University case, this court quoted Justice Levin to say that since the legislature created the duty to bargain, the legislature also had the absolute right to redefine the scope of it. And in that decision, this court said very clearly.
I completely agree with you. I mean, if the statute said, and from here on out, you shouldn't have to bargain about the split, I don't think we'd be here, right? We would not be here. But it said instead, as it sees fit, and one way you could read that is, it wanted to leave room for some bargaining units to get to 90-10, and other bargaining units to get to 70-30. And maybe we want our public safety unions to be able to have that advantage at the bargaining table. I don't know if the legislature thought that. I'm just trying to understand how to think about it.
Presuming that the legislature knows the acts that are out there, which I think is a fundamental tenet, think about it in this way. If indeed this is a mandatory subject of bargaining, which can go to Act 312 with this group, the person who's going to make the decision in this case has nothing to do with the township at all. It will be decided by an Act 312 arbitrator. In other words, that will render this language a complete nullity.
Or you'll be incentivized to come to an agreement with this particular bargaining unit early and in a satisfactory way, right? I'm just trying to figure out.
I understand, but to the extent that everyone's paying 20%, and then now we've got to go bargain with with the UAW and say, well, guess what, now you have to pay 30, then I've got the same issue with them that I had with this group. And that's why it's not amenable to collective bargaining. And that's why, as it sees fit, if an arbitrator decides this, an Act 312 arbitrator decides this, then the employer has no role in the decision. That's the problem here. That's why we think it's permissive. There's nothing wrong with the parties coming together and talking about this. But it cannot, neither party can take it to impasse, because you cannot take a permissive subject of bargaining to impasse. That is an unfair labor practice. And also, you can't take a permissive subject of bargaining to Act 312 under your decision in Centerline, I believe.
Why wouldn't they address this explicitly as being a permissive aspect of bargaining, as opposed to what the current language is, which seems to create a fairly awkward fit between this provision and the provision that lays out the mandatory subjects of bargaining?
Your Honor, I can't speak for the legislature.
Well, that is
I mean, I really can't. I'm sorry. This is probably not it's not the first time this Court has faced issues dealing with statutory construction, and that's what this Court does regularly. I can only look at the language that was promulgated and say to you, this language is clear and unambiguous. It is as the employer sees fit. I would like to reserve, I'll answer any other questions. I'd like to reserve 5 minutes.
I just have one follow-up on Act 312, because you've mentioned it a number of times. And if this was determined to be a mandatory subject of bargaining and it went to Act 312 arbitration, wouldn't there be some constraints on the arbitrator's ability to reach a resolution or an award that would put the township out of balance under the law and therefore violate Act 152?
Well, per se,
wouldn't there be a legal constraint? Wouldn't we then have to view that award as being unlawful or in conflict with the law?
the fact that one group is paying 10%, as Justice McCormick indicated, would just simply mean, under that analysis, I got to run to the other bargaining groups and knock on their door and say, you got to pay 30%. So per se, it does not violate PA 152 if an Act 312 arbitrator did that. And secondly, I would say to you this, that there are, I think, 8 or 9 criteria under Section 9 of Act 312 that an arbitrator looks to. And this would be one of them, might be one of them, but there are other factors like the ability of the employer to pay, what's happening on wages in comparable communities. All of these things together are what, under this Court's decisions in Public Act 312, must be looked at in determining what the award should be. So it wouldn't be based simply on this. There are other factors which an arbitrator may weigh more heavily. I don't know. So,
is there any aspect of this language, in your view, that would preclude an employer from allocating, say, 100% of the cost to 80% of its employees and allocating 0% of the cost to the remaining 20% of its employees? Is that part of the unfetteredness of this language, or are there other provisions of the law, just as you referred earlier to the anti-discrimination provisions of the law, that would give further meaning to this language?
There is a very interesting word in Section 4, because public employers also have, the public elected officials have to pay their same share. And in Section 4, the word is that, T-H-A-T. What it says is that the public employers, the officials, elected officials, must pay their proportionate share of that plan, the plan that they are under. So they cannot take and allocate, say, we want all the other employees to pay our share. They have to, under Section 4, pay their share by the use of that word that. There is nothing else in the section that would restrict the employer, from my perspective, from allocating it as it sees fit.
Counsel, I know you want to reserve some time, so I want to be fair for that. So hopefully our chief will let you come back up, because you've asked a few times to reserve time. But I
probably won't.
Oh. Well, hopefully we'll allow you to come back up, because it's only fair. Because you say you want to reserve time, and then we take all your time. But
okay.
The question I have for you, because I want to get into issue 2, which is the bundling issue.
Yes.
And I guess if you could help me to understand, as I was reading it, there's a certain, and again, help prove me kind of wrong on this, but it seems to be a little bit inequitable and unfair if you're going to have 17 people in a unit, but then you're going to bundle them and you're going to have people who are like, you're putting them together when you're factoring their costs with people who are much older and have all different types of health-related conditions. And so I guess my question to you is, how do you present that in a fair way if basically you're asking for me, if I'm part of that unit, if you're asking for me to have to pay a higher health cost, and I'm part of a bundled unit, but I'm a young firefighter. I'm 25, I'm a young cop, I'm 24, I'm in great physical shape. But yet, don't you think that this is kind of a little bit unfair if you're going to say, well, when you're factoring the costs, we're going to make you pay the same costs as bundling it with people who are older, who are sick, who have health-related problems, where that might not equate to me?
Yes. It's a great question. Let me just say this about the bundled versus unbundled rates. The legislature did not define what a illustrative rate was or what a premium rate is. And here's the thing with this issue. Think about it. We have no, may I continue, Your Honor? Please. You cut me off anytime you're ready to. We do not have any control over that. You have no control over this. If you rule that, in fact, they can't include a retiree health care component, that's not what, you know who makes those decisions? Blue Cross Blue Shield, Priority Health, HAP. They're the ones that make decisions as to what goes into calculating the premium and what goes into calculating the illustrative rate. If you say you can't include that here in this case, and Blue Cross Blue Shield says, who are not party to this litigation, says, hey, sorry, that's how we're calculating our premium, or that's how we're calculating our illustrative rate, we're bound by that. This is, again, one of those issues that's not amenable to collective bargaining. I never sit in negotiations and say, okay, here's what I want to do. I want to negotiate a reduction in the premium rate. We want this plan, but we want it at this rate. Because Blue Cross and Priority and whomever, they tell us, no, you want this plan, that's the rate. You want this plan, that's the illustrative rate. We're stuck with that. And that's this case. In essence, that case is simply, and when the Department of Treasury told us that, and I know it was under Section 3, Section 4, illustrative rates are illustrative rates, they said that it can contain that cost component, retiree health care claims component. Merck disregarded it. Merck had no business. They were outside. The only unfair labor practice we have here is based on Merck's decision to basically disregard what the Department of Treasury said and find that we should have taken a unilateral action when in the past the courts, Merck's been very clear, you cannot take a unilateral action when you're bargaining over a mandatory subject of bargaining, as they claim this
Thank
is.
you, Counsel.
Crazy. All right? Judge, Your Honor, thank you. I appreciate it. Justice Mark.
Good morning. May it please the Court, my name is James R. Andary. Also at Counsel's tables, Mr. Bursch and Mr. James G. Andary. We represent the Shelby Township Police Command Organization, and I would like to reserve a evenly split, as well as I can determine it, for Mr. Bursch to make his presentation as well. When our team discussed the strategy...
You will pay attention to the time. You will pay attention to the time, will you not?
I will, Chief Justice. Thank you. When we discussed the strategy and the strategic issues to present to this honorable court, knowing full well that the importance of balancing the limitations of time with appropriate elocution on the profound issues that this court requested that we brief and present arguments on. After listening to the questions, I'm absolutely certain that the decision we made is correct. And that is to begin with reading the preamble to the Public Employment Relations Act, an act that has been with us for many years. This was an act to prohibit strikes by certain public employees, to provide review from disciplinary action with respect thereto, to provide for the mediation of grievances and holding of elections, to declare and protect the rights and privileges of public employees, to require certain provisions in collective bargaining agreements, and to prescribe means of enforcement and penalties for the violation of the provisions of this Act, and to make appropriations. Equally important, the section that governs the very issues that bring us here today, the Public Employment Relations Act, announces a public employer shall bargain collectively with representatives of its employees and confer in good faith with respect to wages, hours, and other terms and conditions of employment. It's an act that has a great deal of wisdom to it. The underlying philosophy was then, as it is now, to promote harmony in the public workplace. And this harmony is between our public officials, our public employees, and their public employer. As this court has stated many times and has consistently held, the Public Employment Relations Act is the dominant law regulating labor contracts and, most importantly, labor relations. I have to emphasize, and certainly based upon the questions that were directed by the justices to Mr. Lang, that this court has ruled that PARA and its dominance in the public employee relations area is predicated upon the Constitution, specifically Article 4, Section 48. That is the Michigan Constitution. It has been stated and ruled to be the governing law for the public relations. And indeed, the Court of Appeals ruled in its language that was clear that PARA controls in any conflict with any other statute in this particular area. We believe that this statute can be read in harmony with Public Act 152. The Court of Appeals further ruled that since the health insurance benefits are a mandatory subject of collective bargaining, public employees have a duty to bargain about the allocation of the employee's share. It just makes sense. The unfettered discretion of the employer to dictate beyond the 80% is something that they must concede. Public Act 152 simply states a public employer shall pay no more than 80% on the plan that it offers to its employees. Public Act 152 did not amend the Public Employment Relations Act, nor did it exempt public employers from their duty to bargain in good faith on the employee's contribution to the medical health care plan that is provided by the employer. What happened in Shelby Township? The record below is very clear. The record that was exhaustive is very clear. But it appears Shelby Township unilaterally imposed a requirement that each association member pay 25.67% of his or health care costs. Now that's the very question that you were directing to Mr. Lang. They have the ability under their interpretation to require the employee to pay whatever is required from their perspective, and they can bargain to impasse to their benefit if they have the unfettered discretion. Now, this area as it sees fit. We use the description in our brief that they put all their chips as it sees fit. The more appropriate interpretation as it sees fit is that they enable the municipality, the county, in this case the township, to determine what percentages each unit could pay. Now that makes a great deal of sense. And in the abstract, we agree. Although this phrase does give the township discretion on how to allocate the 80% requirement, the whole notion of mandatory subjects of collective bargaining kick in when that discretion is with the employer. So when reading any statutory grant of discretion to a public employer, The employer's decision to exercise that discretion is a mandatory subject of collective bargaining, and that makes sense. Public Act 152 allows the employer to favor one group of employees over another group in the allocation of the total health care plan cost. Just as Viviano said it. Just as an employer has the right to favor employees in a particular bargaining unit with a higher compensation package. The negotiations that should and must take place will enable the employer to say, I can pay more to this other group by way of a more generous compensation package, but I'm going to require them to pay more for their health care. That's what it gives the discretion to, and enables them to do that. It doesn't lock things in and give them unfettered discretion, but it does provide some reasonable way that we can approach it. There are other questions too.
Mr. Andrew,
yes, Chief Justice.
If the legislature had genuinely intended to grant the public employer the allocation discretion that appellant counsel argues, how would they have been better to have achieved that than by the language they placed in the law?
I think they could have clearly dealt with the Public Employment Relations Act.
What would they have said?
And by saying that, if they were going to amend what was permissive and what was mandatory, like we have seen that happen under Public Act 54. It amended the Public Employment Relations Act, and then it's right within the body of the governing board that affects the labor relations for public employees. That's how they could have done it. They could have said this is now a permissive subject of collective bargaining, as opposed to a mandatory. Easily accomplished. What the appellants are urging you to do is to legislate language that isn't there. Have I answered your question, Chief Justice?
You have. Thank you.
Thank you. Thank you. The other issue in terms of...
What about on the Act 312 issue that counsel raises? Does the arbitrator have the authority, if your client is the last group to negotiate, to make an award that would upset go above what the township's allowed to pay by law?
Absolutely not. The standards of the Public Employment Relations Act in terms of the duty of an arbitrator outline clearly the responsibilities they have. They cannot, if the employer comes to them and says, here's the way it lines up for all our employees. And that's another point, Chief Justice, that I should have mentioned. They talk about the entire employee group, including elected officials, in Public Act 152. And proofs will be introduced. I mean, Mr. Lang he's told us how many times he's been in arbitrations and how many times he's negotiated contracts. And without getting how many we've been in, I can tell you that an arbitrator will say, do I have discretion in the area of the allocation of employee benefits? And you can bet that the employer will have presented proofs to say, we can't go over it. And there's no way an arbitrator could go over it, to answer your question directly. They have to follow the law.
So your hope from your client's perspective is that you would be at the front of the queue negotiating contracts?
I'm sorry?
Your hope would be that, from your client's perspective, that you would be at the front of the queue?
We get there as quickly as we can. I think to say it as direct as I can, we would want to be the first in line to negotiate. And we would take into consideration that the benefit package that we are seeking to negotiate for our members would have a reduction of the contributions that they are burdened with now. There's no question. I would want to be first in line.
I assume every bargaining unit's going to have that same interest, right? So
they certainly would.
Yeah.
And to a large degree, that serves a public policy issue, because Public Act 54 was all about that too. What that act took away from us is the ability to have retroactive benefits for a contract we negotiated. It was to urge the parties to come to an agreement quickly and certainly within the context of the expiration date. And under these circumstances, absolutely. Absolutely.
What meaning should we give to MCL 15.567(1) again when it communicates what seems to be the legislature's intent that 2011 PA 152 applies relatively broadly. The requirements of that statute apply to medical benefit plans of all public employees and elected officials to the greatest extent consistent with constitutionally allocated powers, whether or not a public employee is a member of a collective bargaining unit. What weight, what meaning do we give the breadth, the sheer expansiveness of that language?
Within the context of the Public Employment Relations Act, the inevitable consequences of that language is that it has to be determined through the negotiations that take place in good faith. Is it expansive? Does it obligate the parties to approach the negotiations in a fair fashion or in good faith as required to? Yes. Does it change or alter anything in terms of the mandatory subjects of collective bargaining that we urge this court to sustain? No. The other issue, and I know my co-counsel will be taking a good deal of time with this, the red herrings that have been promoted by the opposing party fall into those categories as they see fit, and I've dealt with that issue. The other one is they want you to go strictly by what they believe the language says, but they want you to ignore that the legislature went to great efforts to say retiree benefits can't be in this pool. The retiree benefits, as Justice Bernstein pointed out, are skewed if you include retirees. It inflates them. And I think the wisdom, I'm standing here in the Supreme Court, the wisdom of the legislature was that you can't skew the results like that. Many communities, this doomsday that they project to you is just not true. Many communities have funded retiree benefits separately. And there's no question in this case that they had the rates available to them that did not include retirees. And that's a fundamental part of our position. Finally, and I will defer to counsel, I want to say to this honorable court, the partnering that is now required during collective bargaining is something different than I've experienced in the past. The bargaining process brought about by limited resources and economic downturns has been a fact of life for several years. That's why we believe in partnering. However, I must reiterate, Public Act 152 did not alter the duty of the public employer to bargain over the percentages or the allocation of the costs that employees must pay for the health care benefit plan. We are requesting that this honorable court either affirm the well-reasoned and well-cited case of the Court of Appeals or deny the application for leave to appeal. With that result, we can resume the process of bargaining in good faith with respect to wages, hours, and other terms and conditions of employment, which include the employee's contribution to the medical benefit plan offered to the employees of Shelby Township. Thank you very much.
Thank you, counsel.
Good morning, Your Honors. John Bursch, also on behalf of the command officers. I'm just going to try to tie up a few loose points here. First, I want to stress that there are many everyday examples where someone has discretion to do something as they fit, as they see fit, and yet that discretion is cabined by underlying legal principles. So if a trial judge says to the attorneys before a trial, you have discretion to try this case as you see fit, that doesn't mean that he's dispensing with the rules of evidence or the rules of procedure. They still have to follow those. Or if an owner says to his store manager, you can run the store how you see fit, that doesn't mean that he can ignore principles of labor and employment law that already exist. Just like Justice McCormick pointed out, and as my friend agreed on the other side, in the context of race-based allocation, discretion is always subject to the law. And then you have to ask yourself, well, what is the law here? And this court has already said what it is. For nearly half a century, repeatedly making clear that the public employee benefits are always subject to collective bargaining unless the legislature specifically says that collective bargaining does not apply. And you've said that in at least 5 cases in the last 5 years, all cited on pages 15 to 16 of our brief. And it has to be that way because, as Justice Bernstein was pointing out, if you got to an impasse, then the employer could unilaterally just put all the costs that they want on the employees. And actually, Justice Bernstein, it's worse than that because they wouldn't have a duty to bargain at all. Under my friend's position, they can just unilaterally, right from the get-go, dispense with bargaining and impose 100%. And Chief Justice, when you asked my friend on the other side what limiting principle is there on that simple imposition of 100%, he pointed only to 564 sub 2's requirement that each elected public official pay a minimum of 20%. He said, that's it. Nothing else would restrict the employer. So if they're right, and you choose to dispense with that 50 years of background principle, they could unilaterally implement a 100% payment requirement on everyone. And under Issue 2, they could make every employee pay for the retiree benefits as well. And so really there is no lack of clarity in the language. And just to address one other point, Chief Justice, 567 sub 1, it's true. It says this act applies as broadly as is constitutionally permissible. But all that means is that when there's a doubt about whether Act 152 applies to a certain employee group or a certain employer, we're always going to assume that it does apply. But that doesn't change the way that you interpret Section 4 and the way that it reads against that background principle that unless it specifically says Section 15 is out, you have collective bargaining. And you also ask, well, how could the legislature have done that? Why would they use these strange words as it sees fit? Well, my co-counsel gave you one possible way that they could resolve that. They could have said these are permissible subject to bargaining. Another way, maybe even clearer, would be to say, notwithstanding para Section 15, the employer shall have the ability to allocate as it sees fit. It would have been perfectly easy to do that, and particularly in light of this Court's instruction that the legislature was required to do that in order to set aside Section 15. Anything less than that has to be given that same assumption we've had for half a century.
Under your theory of the case, then, what work does that simple phrase in those 4 words do? What is as it fits, as it sees fit? What does that mean?
Sure.
It's a mandatory subject to bargaining.
Within the bargaining context, the employer has the ability, as it sees fit, to bargain for any percentages that it wants, up to 100%.
Didn't it already have that before this phrase was put in the statute?
Well, the reason you would need it in the statute is because the legislature did do something mandatory here. They said the hard cap in Section 3 was mandatory. Unless you had a vote of the entire township board, then they could choose the 80-20 cap. So the legislature is already acting in an area where they're imposing some non-discretionary duties on the public government. And so this is just reaffirming that, other than that, they do have discretion within the parameters of the collective bargaining process. And it has to be that way.
Do you agree that Justice Viviano's question is really the critical one? You said a few moments ago that most or many exercises of discretion within our legal system are cabined in some way by other principles, such as the anti-discrimination principle, and I grant you that. But in all those other areas in which there are purported exercises of discretion, after the cabining principles have been applied, there's still something left of the discretionary principle, too. There's some affirmative exercise of discretion that's allowed to whatever body has been granted that discretion. I'm just a little hard-pressed to understand the relevance or the reasonableness of the residual discretion that you see here after the application of the cabining principles.
Let me give you 2 practical examples. One we've already discussed. Different bargaining groups could come in and they could negotiate for different percentage allocations. And that's entirely within the discretion of the governing body. And so if they had a need for public perception reasons or leverage or whatever to give the command officers a better deal or a worse deal, they have the discretion to do that. But even more, they've got the discretion to say, look, you pay 100% of this and we'll give you higher wages. Yeah, it's another way that the discretion could be allocated. So within the realm of collective bargaining, there's all kinds of discretion that they could exercise, and they're free to do that. What they can't do is unilaterally impose whatever policy they want against that 50-year background of para always applying to these situations.
I'm sorry, but I'm still not understanding I understand the examples you just gave. I just don't understand why the employer didn't already have that. without that language?
Again, I think it was necessary because the statute was already imposing some mandates on employers that didn't previously exist.
So it's just to clarify that although we've imposed this mandate, with respect to the rest of it, you still have your pre-existing discretion.
Precisely. That's exactly how it interprets.
So you have no discretion. You have to meet the 80-20 or the other. You
Or
have
the
to meet
hard cap.
that. But apart from that, you can negotiate one deal with the command officers and some other deal with somebody else, as long as the bottom line meets our mandatory requirement.
Right, exactly. And that bottom line, the one pushback we get there from the other side, is that if this went to arbitration, somehow that could push the allocation above what the statute requires. And that clearly isn't the case. The policy is actually in a different provision. It's MCL 423.215, small b, sub 4, sub b. And this is in the context of an arbitration where you've got a contract that's lapsed, like this one did. And the arbitrators, as a matter of Michigan law, cannot order an overage that would violate the statute. And that policy accords generally with what we understand Section 312 arbitration panels to be doing, that they can't force them to do that as a matter of law. And as he said, it's unlikely that's going to happen because even if you're bargaining, these things almost never go to impasse. And as Merck made clear in its opinion, even if you go to impasse, if you're not able to reach a resolution, in the meantime, they can impose the 20%. That's something that the law gives them the authority to do. So that's really not a barrier at all. Touching quickly on issues 2 and 3, I think 2 is pretty simple. This is the question of whether they can have the bundled rates with the retirees. And the language in 562 sub F could not be clearer that medical benefit plan costs do not include retiree costs. And the one new argument that we heard today is that employers don't have any ability to impact that because the insurance company could unilaterally only give you a bundled rate. Well, to begin, the power there is in the hands of the employer because they're the customer. And if the Blue Cross folks won't give them unbundled rates, then they can go find another insurer, go to Priority Health or someone else. They're going to be able to find someone in the market to provide unbundled rates. Equally important for purposes of this record, we actually had testimony from John Vance, who was the plan analyst for the township's insurer. And he testified that the provider offered both bundled and unbundled rates. And that's at page 490, small a of the joint appendix, which is part of the Court of Appeals opinion. So that's not really a reason that anybody could use to disregard the plain language of the statute. Finally, then, this third issue, and this supposed paradox that we have, where once they imposed something that was unlawful and bargaining started, that they were prohibited from undoing that unlawful act. Well, that maxim that he applies, that things get frozen in place once the demand to bargain is made, doesn't apply if you're already in violation of the law. And to go back to the racial discrimination, if they had enacted a plan where the allocation was done based on race, the fact that bargaining had been initiated would not impede in any way their obligation to comply with that underlying legal principle. And so that's not really a concern that this Court needs to have. And as the Court of Appeals held, they waived any argument that they might have about the imposition of the remedy here. And there's no need for this Court to dive into that after that holding. Unless you have any further questions, we respectfully request that you affirm or just dismiss the application for leave as improvidently granted.
Thank you, Mr. Bursch.
Thank you.
Thank you. Well, you don't have any time left, but why don't you come up here and let's see if there's any further questions any of the justices have. Are there any other questions? Okay, thank you.
Thank you.
Okay. Case is submitted. Thank you.
Thank you.
Yes, we have several cases this afternoon.
Macomb County case.
I'm sorry.
Both law firms are from Macomb County.
I'm glad to hear that.
Recognized in the morning.
Why don't we reconvene at 1:15, please? Thank you.